Hi, everybody. This is Freedom from Slavery. My name is Donna, and I want to introduce our great guest, John Gentry, who's going to speak to us tonight about our rights to protest the government. Take over, John.
This work, what I'm presenting tonight, this is about restoring the voice of the people in government and literally putting the voice of the people in our legislative houses as well as local governments as well. And if we look at the First Amendment, and there's a reason they put it in the First Amendment right at the top. It's fundamental to our form of government. We have a right to petition for redress of grievances. And that right is so oppressed that it has literally been wiped from our collective knowledge, that nobody knows what this right is or how to even exercise this right. It's like if you took freedom of speech and then everybody forgot what freedom of speech means and what that right is and how to exercise freedom of speech. And this right is more powerful than freedom of speech. It's more powerful than the right to bear arms. So I'm going to share my screen here. This is the National Archives website, has the Bill of Rights. We look at the First Amendment on here. And in the First Amendment, Congress shall make no law abridging the right of the people to petition the government for redress of grievances. Clearly, that's a right that we have. And so I'm going to explain to you tonight what that right means. And this is also in our state constitutions. And I'm going to show you this on the Tennessee Code annotated. You see what that right looks, and I'm showing it to you here in Tennessee Code annotated because this is where it's correct. So on Tennessee Code annotated, here's the Tennessee Constitution, top right of the screen. And they do this intentionally, I think, is they make everything you have to expand to it rather than putting it in a single document that you can look at. And we scroll down here, and it says section 23 is the right of assembly. That is nothing about what this right is. And we're going to talk a lot about this tonight. Here, they just said right of assembly. There's actually three rights in here. Citizens have a right to assemble together for their common good to instruct their representatives. So we have a right to assemble together for our common good. We have a right to instruct our representatives. And we have a right to apply to those invested with the powers of government for redress of grievance or other proper purposes. So the Tennessee Constitution is stronger than a lot of constitutions because we have the right to instruct our representatives. There's only, I think, 16 states that have the right to instruct our representatives. And we're going to talk specifically, what does that mean? Not just redress of grievances. Several constitutions, including the federal constitution, say redress of grievance. A grievance is oppression of a right or discrimination, but we can do it for other proper purposes. What are other proper purposes? That's election integrity, that's term limits, other proper purposes. And we have a choice that we can do it by oral address. We literally have a constitutional right to orally address the body of the House or the body of the Senate, or we can do it in a written remonstrance. So in other state constitutions, this right is enumerated slightly differently. In about 10 states, it says to petition the government or any department thereof, persons entrusted with the powers of government, Delaware alone, applying to the General Assembly, either department of the government in Maine, to petition the legislature in these 4 states, and to request of the legislative body. The other several states are mostly like the Tennessee Constitution, those invested with the powers of government. So this right is clearly established to address, and when we look at these other state constitutions, we can clearly see that this is to address the legislative houses, to go to our legislature and petition for redress of grievance, or depending on the Constitution, other proper purposes in there. And I've got another document up here. This book right here. This is get it in here, a treatise on constitutional limitations which rest upon the legislative power of the states. This was written in 1883 by Justice Thomas Cooley of Michigan. This is probably the most cited constitutional law book in this country throughout the history of our court system. And I'm going to show you what he wrote in here. He said the right of the people to petition the government for redress of grievances is one which would seem unnecessary to be expressly provided for in a Republican government, since it results from the very nature and structure of its constitutions. So what he's saying in here, it seems unnecessary to be expressly provided for. He's saying, I'm surprised. I'm surprised that we've got to write this down. Like, why do we even need to put this in the Constitution? It's so fundamental to our form of government. And it's like saying, we need to enumerate that we have a right to breathe, or that we have a right to procreate and bear children. It seems unnecessary that we even have to write this down. And this next one, this is an admonishment of us today. He says, it is impossible that it could be practically denied until the spirit of liberty had wholly disappeared and the people had become so servile and debased as to be unfit to exercise any of the privileges of free men. He's saying, so this right to die, the spirit of liberty must be dead in us. To allow that this right to be oppressed, the spirit of liberty is dead. When he says servile means eager to please, and debased means removed from our foundation. We're so eager to please and so removed from our foundation that we no longer deserve any of the privileges of free men. So he's saying, just shut up. Don't complain. Just do what you're told. You don't deserve any of the privileges of a free man. And that's not who I am. And that's why I'm here teaching this, to reinstill the spirit of liberty into my fellow man. Let me share back here again. So if we take a look at what the Supreme Court of the United States has said about this in 1876, and I'm taking this to Google Scholar, you can look this up anywhere. So this is the United States v. Cruikshank in 1876. And he said, the right of the people to assemble for the purpose of petitioning Congress for redress of grievances. So let's stop there for a second. The right of the people to peaceably assemble for the purpose of petitioning Congress. What the justice is talking about there, this right of assembly is not protesting in the streets. Protest in the streets, government has no duty to hear. They have no duty to respond to protest in the streets. I personally will never call anyone to protest in the streets. And I found that it just proves futile. I mean, we've seen it in Virginia recently. They had thousands of people show up to support the right to bear arms. And the General Assembly in Virginia just did what they were going to do anyway. The right, people exercising that right of assembly in the streets, it's absolutely futile. This right of assembly is what we're doing here right now. This is the 21st century exercise of this right. We're assembling together, learning about what our rights are. In the past, going to the taverns, the meeting rooms, the churches, congregating to discuss conduct of government that is repugnant to state and federal constitutions, or that's unjust to the people. That's what the right of assembly is coming together to talk about problems. It is not about protesting in the streets. So let's go back to this opinion here. And they say the very idea of a government Republican in form implies the right on a part of its citizens to meet peaceably for consultation in respect to public affairs. And they said in here, the very idea of our government, Republican in form, implies the right of the people to petition for redress of grievances. This is fundamental, and it's got to make sense to you. With powers inherent in people, we the people, in order to form a more perfect union, the sovereignty vests in us. It's absurd to say power is inherent in the people. And I'm taking that's a direct quote from Article 1, Section 1 of the Tennessee Constitution. Power is inherent in the people, and we have a right to instruct our representatives. And to say those things are true, but we don't have a right to orally address our legislature, it's absolutely absurd. All right, so let's look at some of the evidence on a historical perspective on the exercise of this right. So I'm going to take you now. This is the history of Congress, May 1796, and for you guys out there, this is probably the best resource that I've found to understanding the Constitution is the Annals of Congress and the Congressional Globe. These documents, this is on the Library of Congress website, and you can you can read what the founders were saying when they ratified the Bill of Rights, when they were arguing about that. And we're gonna look at some of that tonight. But these are the words of the founders. When we look at the meaning of what the Constitution says today, it's always a supporting authority from the Supreme Court of the United States. These are the judges in black robes. They're absolutely corrupt. And they deceive us and say, this is what this attorney in the black robe is saying that the Constitution means. Don't believe them. Go look at what the founders said. And this is a great resource for you guys out there. So you can see here, I'm on the Library of Congress. And if we go look back here, this is the Annals of Congress that we're looking at right now. They also have on here the Congressional Globe. So if we look at, I'm clicking on Browse the Annals, we can see the volumes. This is the first Congress, second Congress. And if you scroll down to these, I'll look at the first Congress, and you can see the first session, the second session. And attached to these, they also have appendixes. And the appendixes to the Annals of Congress and to the Congressional Globe, they actually include speeches that were made in there. So we're looking at this on May 17, 1796. And this is in the United States Congress. The House resolved, I'm looking here in the top right of the page, if you can see my mouse, the House resolved itself into a committee of the whole. So that at the time, that's the 13 colonies, all the representatives, 50 something of them, and they're all going into a committee of the whole. So that's all of them. On the petition of Jonathan Hastings, Deputy Postmaster of Boston, praying for recompense for his extra services in receiving and dispatching English mail for 2 years. It was recommended that he should have $200 allowed, which was agreed to, and a bill ordered to be brought in. This next one, Mr. Swanwick presented a petition and memorial from Richard Garnon and Company of Philadelphia, praying that the bill proposed passed to repeal the act of allowing a drawback on exported snuff might not be brought into law, as they should suffer greatly for such a repeal, having made considerable contracts abroad, which they should be under the necessity of completing. The memorial was referred to the Committee of the Whole, to whom the bill on that subject was recommitted. So here you can see, this is clearly a congressional record on the Library of Congress. And you can see that petitions were presented to the United States Congress. So let's go back and look at some more evidence here. Next one, this is on the United States Senate website. And if you guys haven't read this, you ought to. So citizens of Philadelphia, where's this at? Here it is. Citizens of Philadelphia, pull this up a little bit, petition the Congress to commemorate the 130th anniversary of Washington's birth by reading the address at a joint session of the houses. On that day, members proceeded to the Capitol to hear the address by Secretary of the Senate. Early in 1888, the centennial year of the Constitution's ratification, the Senate recalled the ceremony, and its presiding officer read it on February 26th. Within a few years, the Senate made the practice an annual event. So here you've got, this is on the Senate website, and there is proof that petitions were received. You know, here they're just asking them to read Washington's farewell address. And I encourage you to go read Washington's farewell address on the National Archives website, where he warned us about the corruption of political parties. He gave us quote, his most solemn warning. That's another topic, not part of this, but you can see it clearly on the Senate website that citizens petitioned the Congress, and the Congress acted on these petitions. Let's look at some more here. Historical petitions. I got these from the Tennessee Archives website. Let's see if I can navigate to this quickly. So this one here, this is one from this is actually from my fifth great grandfather, filed in the year 1801. Let me bring this up here. So this is the form. This is what it looked like in 1801. To the Honorable General Assembly of the State of Tennessee now sitting, whereas your humble petitioner humbly showeth that he was so unfortunate as to become lack for the appearance of a certain Archibald affair at a superior court of law. And he failing to appear, my something became forfeited for the sum of $100. So I guess $100 was a lot of money back in 1801. And so he was petitioning the General Assembly to forgive him that. Here's another one. That was actually another Gentry. Let me see. This is the cover. This is one in 1820. And this was, the paper was folded up. The petition is actually on the other side. Petition of Allen Gentry. That's the one that I just showed you. So that petition was written on, this is the petition here. And that was written on the other side of that. It was just sent by postal carrier to the General Assembly. And this is in the Tennessee Archives Library. So while I was in that archives library, this is a house journal from 1831. And anybody can go look down at the archives library and find this. And in there, in those pages, you can see here, Mr. McGahee from the Committee on Propositions and Grievances reported a bill to authorize awesome Gresham to sell a slave, which bill was read a first time and passed. Mr. McGahee from the same committee made a report on the petitions of Baker, Stanley, and Terrell. Resolution concurred, resolved. The prayer for petitioners ought not to be granted. Another page here. Let me blow this up. Mr. Hurst presented a petition of Alan Jack playing for a divorce. It was referred to the divorce committee. Mr. Hardin presented a petition on Joseph Nolan, praying the passage of an act authorizing him to hawk and peddle without a license, referred to the Propositions and Grievances Committee. Mr. McGahee from the Committee of Proposition and Grievances made a report upon the petition of sundry citizens of Franklin County praying for the passage of an act authorizing them to raise a sum of money by lottery for the purpose of erecting a female academy. Resolution concurred. The prayer ought not to be granted. They didn't like divorces back then. So these are like right out of the 1831 House Journal. There's some more in here. these were petitions for divorce. They used to hear divorces in the General Assembly. These 4 people were denied. Let me close that down. So you can clearly see in the United States Congress, they heard petitions. You can clearly see in the Tennessee House Journal that they not only just heard petitions, but that they were referred to committee. The committee would discuss them, look at the evidence, consider them, debate them, listen to witnesses, and then they would make recommendation back to the body. If there was discussion, they would talk about it, on the floor, and then they would vote on it, whether to grant or deny the redress that we sought. This is an incredibly powerful right that we have that's been so oppressed, nobody knows what it is. Let's look. This is the 1870 Constitutional Convention. So I got this through the chief legislative librarian at the Tennessee Archives, and this is from Michigan Law Library here. So I'm just going to Control F, fine. So they do a roll call. Petitions are the first order of business. So roll call was called for petitions and memorials. Mr. Baxter from the Committee on the Bill of Rights made a report asking for further consideration of petitions referred to them. So citizens were actually petitioning on Article 1 of the Tennessee Constitution here. Roll call for petitions again, submitting the following resolutions to refer them. Here, Mr. Thompson of Maury County presented a petition from numerous citizens of Maury asking the clerks to be elected by people of their respective counties. Here's a petition referred to new counties. So they were petitioning for new counties. And there's actually, so that's the 1870 Constitutional Convention here in Tennessee. And there were about 30 petitions. Some of them were, they wanted Tennessee or wanted a specific county to be a dry county, no alcohol sold. A lot, some of them were on what they wanted the Bill of Rights to be. A lot of them, probably most 15 or 20 of them, were about forming new counties in there. So you can clearly see, even during a constitutional convention, these guys, the first thing they're doing is a roll call. Do any of the members have a petition that we need to hear? That's the way our legislatures are supposed to act. And we're going to see evidence of my exercise of that right today. I mean, like literally in today's legislature, we're going to see that. Get back to my share here. All right, so we've looked at the 1831 House Journal. We've looked at congressional records. We've looked at state legislative records. Let's look at rules. So, yeah, let me jump over here.
John, what was that first book you held up and said, this is the #1 reference?
Say that again.
What was the book that you held up and showed everyone?
Okay, and you guys you got my email on there. You're welcome to email me. This is a treatise on the constitutional limitations which rest upon the legislative powers of the states of the American Union. You can see there this was written in 1883, and this is Justice Thomas Cooley. This book has been cited more times than any other book out there. So this is from the Tennessee House of Representatives. This is the permanent rules of order. And how you get to these, go to the Tennessee General Assembly website here. And from the legislation, or actually House name, you can click more, and here's House publications, and here's the rules of order right here on the General Assembly website. That's the document that I just brought up. We go look at Rule 15. Before any petition or memorial addressed to the House shall be received and read at the table, a brief statement of the contents of the petition or memorial shall be filed with the chief clerk. So it's right here. Petitions shall be received and read at the table. It's in their own rules. If we go down to Rule 79, Rule 79, if any question shall arise which is not provided for in these rules, the same shall be governed by Mason's Manual of Legislative Procedure, latest edition, existing on the date of adoption. So this is Mason's Manual of Legislative Procedure. So it's like this is like an 800-page book. Get in front of my camera. This is about an 800-page book in here, and I've got an electronic copy. I have a subscription to this. I forget how much it costs. You cannot buy these on Amazon. You have to buy them from the publisher, which is the National Conference of State Legislatures. You have to go to the National Conference of State Legislators, and from their website you can order it. It's the only place. I mean, with their copyright and anything, they will not allow this to be sold anywhere else. That's the only place that you can get it. So let me go back and share my screen here. And I think they've, yeah, okay. So here's this is in section 149. Here's section 149, communications and petitions. So there are, let me see if I can blow this up. No, I can't. I can't make this bigger for you guys, sorry. But I'm reading right here. There are many instances when a proposal is presented to a legislative body by communications or petitions. The communication may come from the executive, judicial, local government. The right of petition is usually guaranteed in the Constitution and presents a means by which proposals can be presented to the body. A petition is a written document addressed to a legislative body in which it is to be presented, containing a title or designation of the petitioner of the subject matter upon which the petitioner substantiates a claim for desired action by the legislative body. So what they're doing here in subparagraph 2 of 149 is they're saying this is the construct. So what's your claim, the specific request? Remember, it's a right to petition for redress agreements. You got to tell them the redress that you want. The prayer in which the object of the petitioner is expressed, signed by the petitioner, embodying instructions or opinions or requests of the legislative body to exercise its authority. In paragraph 3, when the object is for common interest or good or for the redress of some public grievance, it's a public petition. When the object of the petition requests action of the legislative body, usually for a particular interest, it's a private petition. Now listen to this, paragraph 4. A petition is presented to the body by the petitioners themselves, or by a member on behalf of the petitioners, or by filing the petition in the office of the chief legislative officer. When a communication or petition is received, it may be acted upon as any other business. So you can clearly see in their own rules that they have out there, that they have a process for adjusting these things. I'm just closing down some links while I'm talking, and I can't do two things all at once. I don't multitask like that. But you can clearly see that these are in the legislative rules. I'm not making this stuff up. One of the things, let's see, am I off? Yeah, I'm still off screen share. So one of the things I did in my first remonstrance, let me see. Okay, this is the first remonstrance that I filed with the Tennessee General Assembly in 2019. You can see I filed this directly with the Chief Clerk of the Senate, and you can see it's file stamped, and that's Russell Humphreys is his name. And in here, I put in a jurisdictional statement. And included in that, I cited Mason's Manual, section 518, which says a legislative body can't delegate its powers. The power of any legislative, this is what used to be in section 518. The power of any legislative body to enact or take final action requiring the use of discretion cannot be delegated to a minority, to a committee, to officers, members, or to another body. Now, that was Mason's Manual 2010 edition. This is the 2020 edition. And you can see, if I can get this up on the screen, well, that's section 7. If I turn to the very next page on this, if I can get this in here, sorry. The very next page, I'm not showing that very well. The very next page is 520. And what they did is they actually deleted section 518 out. So this work is having such an impact that I'm doing here in Tennessee that I caused the National Conference of State Legislatures, they're like, Gentry got us on this one, that we can't delegate this. We have to hear it as a body. We can't delegate it to a member or to a committee. We've got to decide it as a body. And there's another part, and I talk about this in a book that I wrote about the Tennessee Constitution. It talks about hereditary emoluments, and nobody knows what that means either. But it's about, you can't deputize, you can't make an office heritable. Offices of trust are not heritable offices. You can't deputize somebody else, and an emolument is compensation received for office or any advantage, profit, or gain from office. And so you can't delegate these things out under the emoluments clause of the Tennessee Constitution, but they literally, the state legislative or National Conference of State Legislatures, they rewrote the book because I used their own rules against them. Let me move on here. Share my screen again. Let's look at, this is the United States House of Representatives. And you guys can Google this. If you just Google United States House of Representatives Rules of Order, this is the document that you're going to find. And I think, yeah, it's page 29 on the PDF, document page 25. So if we go to page 29, and here this is the United States Congress House of Representatives Rule 12, petitions and memorials over here on the right-hand side. Here you go, petitions and memorials. If a member, delegate, or resident commissioner has a petition, memorial, or private bill to present, the member shall sign it and deliver it to the clerk, and may specify the reference or disposition to be made thereof. In other words, specify the reference or disposition, what he thinks should be done. Such petition shall be entered on the journal, and it shall be presented in the congressional record. So you can see that this is the United States House of Representatives. It's in their rules. And we just as an aside about, like, how do we exercise this right today, and how it could make a difference today in the United States Congress. Half the people in this country believe that we had election fraud for the election of our president in 2020. And I don't care which side you stand on, it's a problem that half the people don't believe that we had a proper 2020 presidential election. And what Trump did is he called his supporters to come to Washington, D.C. And I don't care how you look at that, it didn't end up well. And we've got, probably good citizens that are being prosecuted maliciously and incarcerated just because they were standing up for what they believed in. But what should have happened is President Trump should have prepared a memorial and remonstrance. He should have got that co-signed by 80 million people that voted for him. And he should have presented it to a member of the United States House who has a duty to file it with the clerk according to their own rules. And according to custom and usage, like you saw in Tennessee, and like you saw in the congressional record, it would have been referred to a committee. And they could have done it as a committee of the whole, or they could have sent it to a special committee. And President Trump would have been able to present his evidence, and the people would have been on C-SPAN, and we would have said, he's full of beans, or we got a problem here, guys, we need to fix this. And the redress that he should have sought would have been an audit or maybe a do-over. That's what I would have done. This rule also exists in the United States Senate, but to get to the Senate, it has to be signed by the President of the United States. And only then will the United States Senate hear a petition. It has to go through the President first. But in the United States House of Representatives, you just send it to any member, and they have a duty to file it with the clerk, and you can see it's entered onto the congressional record. Let me show you what this exercise of this right looks today. This is the announcement of my remonstrance on the Tennessee House of Representatives floor.
Next order, Mr. Clerk. Petitions and memorials. Mr. Clerk. Mr. Speaker, pursuant to Rule 15, we have a brief statement regarding a petition of remonstrance statement filed by Representative Halsey. It reads, I'm approaching the Tennessee House Chief Clerk on behalf of Mr. John Gentry with this petition and statement. Involves a petition of grievances. 1, unconstitutional and void statutes. 2, failure to address grievances. 3, judicial reform. 4, reinstitution of constitutionally guaranteed rights. Signed, Bud Halsey, Tennessee State Representative. From that
announcement, I went down to both the House and the Senate. I tried to file it, and the Chief Bletzler, Clerk of the House, said you can't file it with the House Clerk. It has to be filed by a member. So I went and found Bud Halsey. He's not even my representative, but he upheld my right. He agreed with some of the things that I had in my remonstrance. And so Representative Bud Halsey did his duty, and he filed it with the Clerk of the House. And you can clearly see this was announced on the floor of the House. Now, I just proved to you that we have a right to do this. You can see it in the history of Congress. You can see it in the history of the Tennessee General Assembly. You can see it in their rules, and you can see it announced on the floor of the House. The result of my remonstrance. So I was at one of the things I was complaining about was reforming the judiciary, and I wanted the Tennessee Code or Tennessee Board of Judicial Conduct. I wanted them abolished because that corrupt agency does nothing but protect corrupt judges. And you can see here, this is Tennessee Code annotated. As of July 1st, 2019, the existing membership of the Board of Judicial Conduct is vacated. You are out of office. They literally threw about, I think it was 12 or 14 judge members of the Tennessee Board of Judicial Conduct, Disciplinary Council. Y'all are out of here, gone. Like, they removed them from office. That was at that time, I had no public persona. I wasn't a public figure. I was just John Gentry, angry citizen and having my rights violated. And I stood up to them, and they vacated the entire Board of Judicial Conduct. And you think about it, I did that as a single citizen. What can we accomplish if all of us want the same thing? And I can tell you, all of us want term limits. All of us want election integrity and election transparency. And we can accomplish those things if we as a people unite and assert this incredibly powerful constitutional right that we have. Get back and share again here. So this is February 23rd, 2023. This is another remonstrance because I'm out educating the people. Now this one, I didn't make a copy, but I want to show you how to navigate this and get to the video yourself. So this was on February 23. So you go to the General Assembly website, go to videos, go to House Journal. And on on the House Journal website, click, this is in the 113th, and we're going to go to floor session. And then down here at the bottom, we can see the floor session. So that was on February 23rd. And they index these by what action they're taking. So you can see on the left-hand side. And so I'm going to select petitions and memorials. I'll make this full screen.
Next order, Mr. Clerk.
Petitions and memorials.
Mr. Clerk.
Mr. Speaker, we have a brief statement dated February 13th, 2023, addressed to the Honorable Tammy Letzler, Chief Clerk of the Tennessee House of Representatives. It reads, Dear Madam Clerk, please accept the attached application by address from Arthur J. Hirsch of Lawrence County, Tennessee. Mr. Hirsch seeks immediate dissolution of the unconstitutional Board of Judicial Conduct by this legislature on the ground it clearly violates Tennessee Constitution, Article 6, Section 7, judges holding prohibited office. Signed respectfully, Clay Doggett, State Representative for District 70, Chairman of Criminal Justice Subcommittee. Mr. Speaker, this application by address is available for review by any member who wishes to do so.
Thank you, Mr. Clerk. Chairman Zachary, you're recognized.
Okay, so now let's take a note of a couple things that happened there. He said, Mr. Speaker, I have a brief statement, right? Now, when we read Rule 15, it said petitions shall be received and read at the table. What they're doing is they're reading the brief statement. They're not reading the petition. And in that application, he said by address. So that citizen is asserting his constitutional right to address that legislative body and explain to them why the Board of Judicial Conduct is repugnant to the Tennessee Constitution, which it is. It is in gross violation of the Constitution because it has judges, and judges are prohibited from any other office of trust in Article 6, Section 7. So they're reading the brief statement. At the end of it, he said, this petition is available for inspection in the clerk's office. What should happen, and what I'm fighting for, is our constitutional right to orally address them. The Constitution, I just showed you in the very beginning, it says we have a right to apply to those invested with powers of government by address. We have a constitutional right to orally address them. And corrupt Speaker Sexton is oppressing that right. He refuses to allow a citizen to address them. Like these guys are our rulers and we are our subject. We are their subjects. That is not our form of government. And you saw in the right in USC Cruikshank that this right is fundamental to our form of government. It is fundamental in our state constitution that we have a right to orally address those with those invested, excuse me, with the powers of government. And you can see from the other state constitutions that we have a right to petition the legislature, petition the General Assembly. Of course, we have a right to address the General Assembly. I'm literally in the trenches fighting these guys to restore this right.
Mr. Gentry, you reserve 3 minutes.
So let's talk about rules, Your Honor. This is the legislative rules of order. Rule 15, petitions shall be received, read at the table. Shall creates a duty. Petitions shall be received and read at the table. Rule 79, anything not governed in the permanent rules of order shall be governed by Mason's legislative rules of procedure, latest edition. This is the latest edition. Section 149, subparagraph 4. Petitions are presented by petitioners themselves. This is a constitutional right that we have. When we talk about separation of powers, what it says is you're not supposed to exercise legislative powers. They're not supposed to exercise judicial powers. It says nothing about one branch not interfering with the other. Article 6, Section 7, judges may be Article 6, Section 6, judges may be removed by concurrent vote of both houses. Article 5, judges can be impeached. So can the legislative branch interfere with the judicial branch, and the judicial branch can't interfere with unconstitutional legislative conduct? It's absurd. Of course, the courts have the power to interfere with government. And she says the Constitution is not clear. Constitution is not clear. That would make it void for vagueness. And the Constitution is not vague. It is clear we have a right to address those invested with the powers of government. Their rules say petitioners are presented. Petitions are presented by the petitioners themselves. It's in their rules. They have a duty. It's a constitutional right that we have. And let's talk about how important this right is. In the book Constitutional History. So what I wanted you to see with that, like, I'm fighting, but I can't do it alone. And the people need to get out there and start. And I've got a call to action in this that I'll share what we can do, or what you can do as citizens out there to start fighting to restore this right of the people. Government is going to come up with some excuse, and I don't have time to go through it tonight, but they ended up upholding that Court of Appeals. Even after my oral argument, they ended up upholding dismissal of my case, where I'm seeking an order of the court to order Speaker Sexton to present me to the body because I have a right to address them. And the whole proceedings on this thing are corrupt, but they're doing it because they can get away, because the people are in this coma of apathy and distraction, and they just don't care. And if we don't start caring, I mean, Justice Cooley, the spirit of liberty must have wholly disappeared. And I hope that is not true of the people that are listening to this presentation today. So let's get back to, so I'm going to skip more on defending this. I do want to talk about this exercise.
John,
What? Say again?
I have a question for you.
Yeah.
Here's a question. They want to know if this petition that you're talking about, does that come all the way down to the local government as well, or only at the state level?
Well, you have a right in the First Amendment of the United States Constitution to petition for redress of grievances. And typically that is to the United States House of Representatives. In the Tennessee Constitution, every state constitution, and it depends, North Carolina is to the General Assembly only and for redress of grievances. Texas, Kentucky, Tennessee, we can petition for redress or proper purpose, and we can do it by oral address or by remonstrance. So it depends on the state constitution. So you've got to go look and see what your state constitution is. Tennessee, it's those invested with the powers of government. Right now, I'm applying to my county commission to ask for their recommendation to impeach a corrupt judge. And I believe that I'm probably going to get a county commission to make that recommendation so that we have a whole county of elected representatives recommending removal or impeachment of the judge. And so this is another mechanism, another alternative of how we use this right, because Tennessee was broad. I can apply to those invested, and the county commission is certainly invested with the powers of government, so I'm applying to them. And I don't take no for an answer. How to exercise this right? Let me go. I think, yeah, I have a simple flow chart here. I think it's this one. Yeah. So this is really simple how you do it. You prepare your petition or application. You go out and get signatures. You present the signed document to your senator or representative. Your senator or representative files it with the clerk of the House or Senate. The application is announced on the floor. After it's announced, it should be presented by the petitioner or by the representative. They're oppressing this part right now. They're just reading the brief statement. Historically, you saw that they would send it to a committee for discussion. Now what they're doing is they're saying it's available for inspection. They're not sending it to committee because they're corrupt and they want to oppress this right. And then the committees, historically, they would make a recommendation back to the body and they would vote on it. So very simply, that's how they're doing it. That's how they're doing it today. Now, I wrote a book about the Tennessee Constitution, and I'll share with you what that looks like electronically. And in here, I have the explanation on section 23. And I go through, I talk about a lot of the stuff that we did, talk about the right to instruct representatives. And then I've got how to exercise it. So we just looked at the flow chart. Here's an example. This is the second one that I presented. And this is very similar to that one that Mr. Hirsch. Did I lose you guys? Can you still see me?
I'm here. I'm here.
Okay. All right, it just dropped for a second on me. But so this is all it is. You don't have to use the fancy font that I did. But you're saying, you know, just like my fifth great grandfather in that 1801 petition to the General Assembly of the state of Tennessee now sitting. And then according to Mason's manual, you know, who's presenting it, what's the subject of it, and then, you know, a brief introduction and signed. This is what I presented, and this was announced on the floor of the House in 2021, I believe. And I'm just saying, I went around and I got signatures, and I said a large number of citizens across the state were making application by address. And we're also asserting some other rights. And then what do I want? This application made by good citizens seeks resolutions for the members to welcome here petitions and remonstrances and to hear and decide them according to our Constitution. And I'm also asking them to reinstate the Propositions and Grievances Committee. That's all I want them to do. So did I just close that? Rats. Let me get back to that. Sorry. So now I talk about in here on how to exercise this right. This is my book. You can buy this on my website here, or you can purchase it from my website. But this is actually in the book. That's that early petition that I showed you, what they look like. Go through the rules that we talked about. Now I put in some other things. In historical petitions, it was just signature only. In today's world, I suggest you get co-signers and include their complete physical address, email address, and phone number. And I did this on that one that I just showed you. I did it electronically through MailChimp. I took electronic signatures through there, and I had a checkbox on there that if they check that box, they were submitting to agree to use an electronic signature under Tennessee Code annotated. Electronic record or signature is attributable to a person as if the act of the person. So that's a statutory requirement that I threw in there as an extra step. And then once you've got that petition, you've got all the signatures about it, then you send it to your senator or representative. Now, some of these guys are saying, no, I'm not going to file it. And that's what happened with my second one is, you know, I was getting pushback from my representative just to ask them to welcome here and decide petitions. He didn't want to file it. And I was like, Johnny Garrett, I don't care you don't want to file it. You're going to file it. Or I'm going to file a petition for writ of mandamus against you in Chancery Court. And I'm going to get the court to order you to do your job. And so, you know, he met with me and I gave him the application. Same day he filed it with the clerk. Same day it was announced on the floor of the House. So that's, that's like a really quick rundown because I'm getting too short of time because I talk too much.
No, you have until a quarter after. You're good.
All right.
If you guys have any questions, you can type them in.
All right. So we went through very quickly about how to exercise that right. Let's talk about, what are we going to do? How are we going to restore this right? If you're in Tennessee, I would say call the Court of Appeals. And I don't have time to go through it right now, but I can show you the proceedings are corrupt, and the corrupt court is trying to prevent me from exercising my right to address the legislative houses. So tell them, call up the Court of Appeals and tell them the people are watching this case number 2022-00654. Tell them you're watching that state and tell them to do their job and enforce the Constitution. If you stay silent out there and these judges think that the people aren't watching and they don't care, they think they can get away with corrupt court proceedings and they'll just dismiss the case and uphold dismissal. Call your senator and representative, tell them that you are outraged that Speaker Sexton and the courts are oppressing this right. Did I not prove it to you people that we have a right to address them, that it's in their rules that petitions are presented by petitioners? I've proven this fact historically using government websites. Everything is linked for you to go look at yourself. I'm not doing anything tricksy here. I'm giving you concrete evidence on government websites that we have a right to do this. Don't stay silent. Tell other people. We all need to stand up. We all need to stand up for this right. So call Speaker Sexton and say, I know that we have this right and I'm outraged. Call your senator and your representative and tell them that you're outraged about Speaker Sexton and that your representative or senator also ought to be outraged. And tell them the people are watching this case. Tell them to enforce the Constitution. And tell them you're going to hold them accountable at the polls, even if you got to go vote for a Dem. Maybe that'll get their attention. Even better, if you can do this, go to the Capitol. Your representative of your district will meet with you and tell them that you have read the Constitution, you've looked at the historical evidence, you've looked at the Library of Congress, and everything says that we have a right to do this, and tell them to stop oppressing this right of the people and uphold my right to address the General Assembly. If you can find other speaking engagements, I'm happy to go talk to anybody out there. Talk to your friends and family and tell them about this work. You can get out and go to party meetings, talk to the citizens. Don't talk to the organizers. They're probably part of the corruption. Talk to the people that are there and invite them to a meeting like this. And if you can't do anything else, do what I'm doing, run for office. I will help you. If you're interested in running for office, you don't need any money. You just need to put in some effort. If you want to learn more about the history of this right, I have a law review article. This was cited by the Tennessee Court of Appeals. It's about 30 pages. It goes through the history of this right going back to the 12th century. And if you want to buy my book or make donations, it really helps me. I spend $300 to file the case, $500 in the Court of Appeals. I spend thousands of dollars on court reporters, all comes out of my pocket. If you go to my website, wethepeoplev50.com, and I'll drop a link in here. Even if you're from another state, the way that I explained the Tennessee Constitution, a lot of the stuff in there is similar to other state constitutions that, if they haven't been changed too much out there. So I'll drop in the chat. This is a link to my website right here, and you can purchase my book. It helps me a lot. I would be grateful for that. And you can learn a lot about the Tennessee Constitution. You're not going to learn anywhere else in any school at any level. It's not even taught in law school. So if anybody has any more questions, let's see.
We sure do. Somebody asked, how do we pull 4% of the 280,000 people together to understand this tool?
Well, you do what I'm doing. I mean, this is not, we're going to do it tomorrow. This is long game.
Yeah.
I've been working on this for years. And, you know, during my election, I was reaching, 100,000 people. Probably most of that 100,000, probably 60,000 of them know what I'm doing. But we've got to keep pressing the fight. So how do you let them know? I ran for office, first time for state senate. I got a lot of attention. Then I ran for governor. I got way more attention. Now, the advantage to that, to running for election, on Facebook, I created a political candidate page that's different from an individual person page, and it's different from a business page. I registered with Facebook as a political candidate. What I had to do is I had to send them proof of forms from the Election Commission that I'm a political candidate. And I had to send them a copy of my passport and my driver's license. I think you can do other documents instead of a passport. And once I satisfied their documentation requirements, they sent an alphanumeric code to my house. And then I took that, it came in the mail to my personal residence, and I entered that alphanumeric code into Facebook. So now I've got a political candidate page that I'm authorized to advertise on. And I can show anybody who wants to do that how to advertise. And who cares if you've been running for office? Use it as an advertising medium. Run for county commission, who cares? Run for state house, doesn't matter. Pick an office, run for mayor, it doesn't matter. As long as you have a political candidate page, now you can start advertising. And there's a little box when you advertise that this is about social or political issues, and they won't oppress you. And even though I talk about corruption incessantly on my page, I'm not censored. And my posts get out. I sent out the video of my oral argument, got 57,000 views on that. I've had other posts, I get 50,000 likes, and it's because I use the tools wisely, and it's cost effective. I pay like 1 to 3 cents an engagement. It's nothing. Every time somebody clicks on it, it costs me a penny. I mean, it adds up when you've got 50,000 pennies. It's still a lot of money for me. But this is how you use a tool like Facebook that is anti-conservative. I don't ever share links when I use my Facebook page. I write my own content. I argue the Constitution with my own words. If I cite anything, it's the Supreme Court of the United States. I never put links in the body of my posts. Facebook sees that and says that's somebody else's post. And you're sharing it, and the only people that are going to see it are the people that click on your page. You've got to know how to use the tools that are out there. So never put a link in a post, and don't share links about what they consider conspiracy theories. Write your own content, talk about the corruption, talk about this, right? Advertise it out there. Use Facebook wisely like that. It's been extremely effective for me. And it takes persistence. I've been at this since 2019. I've been trying to teach the people about this, right? And there are tens of thousands of Tennesseans. I'm at about, I would like to see 400,000. And, out of the 400,000, I'm probably 10% of the way there, and it's gonna escalate, and it's gonna ramp up, and it'll get faster and faster as more people learn about this. And then pretty soon it's going to be an avalanche and snowball effect, and the General Assembly is going to come into compliance with the Constitution. Any other questions?
Yeah. Would you deal with groups differently than individual people, like on Facebook? How would you get to groups?
I have a Facebook group, We the People, V50. I don't find it effective. And I can't advertise out of that group. That's why I'm saying do a political candidate page and learn. I'll give you a class. Anybody that wants to do it, I'll show you how to advertise with Facebook. It's not hard. I'll do it right now. I'll show you what it looks like and how easy it is. It's a little harder to get the account set up.
Well,
Joe-
we're kind of running out of time. Can I ask you another question instead?
Yeah, while I'm doing this is really super quick.
Okay,
So,
multitasking. Go ahead.
so this is my candidate page. And because I have an advertising account, I got a little boost post button there. Can you see that? Boost post. So I click on that boost post button and I can change how I want to advertise this. Do I want more messages? Do I want more engagements? I can click a button, shop now, if I want to send people to buy my book. I typically do no button because when people share, if they're sharing, it doesn't put anything except for the link. So I almost always go no button. And then you have to do, what kind of category is this? I have to always do it on social issues. And this has to be approved by somebody there. I can choose people through targeting. If I click on this, I can set the age group, I can set it to a city, I can set it to a county, I can advertise to men, I can advertise to women only, do whatever I want with it. And that's how simple it is to do advertising with Facebook. It takes me 10 seconds to do an ad. It's going to take an hour or two to learn how to create the account and a week to get all of the approval and everything. It's that simple to advertise on Facebook, and I'm happy to help anybody. But that's how you do it. And the only way you're going to be able to advertise like that is if you're a political candidate. So run for village mayor. I don't care. Just use that as a means to do it.
Well, another question came in. It says, how many LFP, Liberty, Freedom, Patriot groups are in Tennessee that have refused to help you?
I reached out to Tennessee Stands and I said, will you help me teach the people about the right of remonstrance? No response. I reached out to Tennessee Freedom Fighters, pretty large following with them. I said, will you please help me teach the people about the right of remonstrance? No response there. I have pretty much given up on going out and approaching anybody and asking them if they're going to help me. I bring my case to the people as best I can, through my social media pages, my YouTube channel, my website, my Facebook page, and I invite and I welcome anybody with open arms that wants to help me. And I will help them back as much as I can.
So John, I'm going to ask you a hard question. It sounds like you're having trouble allowing you to do what you have a right to do. Could people be discouraged by that? And maybe that's a challenge?
I guess if the spirit of liberty is dead in them and they want to quit like a coward, yeah, they can walk away. I'm not.
Good answer.
For us to say, I hear this, it's going to take, the only thing that's going to work is we got to take up arms. And I'm like, you haven't even tried. What have you done? Have you even bothered to pick up the phone and call your senator or representative demanding restoration of this right? Have you even bothered to pick up the damn phone? And more times than not, they haven't even bothered to do that. They won't even take 5 minutes to answer the phone. But I'll tell you, there are thousands of people that do support the work. I went to that oral argument hearing. I put out a Facebook post. I had probably 30 people attend that oral argument to physically come down there. I had people drive 3 hours from Central and East Tennessee to come listen to that oral argument because I asked them for their support to show the court that the people care. So there are people out there that are willing to step up and do their duty. They're just looking for the call to action. They're looking for the right man, the right work to follow, and they'll get behind them. So I'm not, there's a saying, when one strong man stands, other strong men will come to stand with him. And then multitudes hardly thought to exist. So I've got a few people standing with me, more are coming. And when I have enough strong men to come stand behind me, then the multitudes are going to come follow, and this thing's going to happen overnight.
Well, you got a lot of amens out there coming your way.
Well, I mean, obviously, I mean, I do everything that I can with these court cases, you know, the personal money, the time that I put out there doing meetings like this. I'll do it anytime I can to try to help people. And I think, did I not prove a good case to the audience tonight that we have this right? Did I not make a good argument?
Absolutely.
So now it's our duty, you know, to stand up and educate others. Like, wow, did you know that you can stand in front of the, you know, you hear somebody, you know, bitching about something. Well, do you know you can do it in front of the entire General Assembly? You have a right to do that. You know, that this is what we need to fight for. And, you know, little by little, these guys, I am kicking their butt in the Tennessee Court of Appeals. I really am. I mean, they denied me at first. I went in and I filed a motion to disqualify and a petition for rehearing. And I got 3 responses from 3 separate judges in my, you know, to my motion to disqualify them. One of them was very favorable and respectful to me. One of them was outright arrogant and disrespectful to me. The other one was in the middle, but I crushed them in argument in my petition for rehearing. And the only way that they're going to be able to get out of this is if they evidence their corruption. And that's what this is about. I know these guys aren't going to uphold my rights till I back them in the corner. And so that's what I'm doing. I'm painting them in a corner they can't get out of by arguing the Constitution and doing my homework from these bozos.
Absolutely. And we have to get up and stand with you. And like Angie says, we need to exhaust them. You know, one gnat, you can swat it away, but a swarm of flies can eat a human being, right?
Yep. That's what,
So,
you know, that's what's going to take is tenacious persistence. You know, I started out, I went to the Supreme Court of the United States trying to get things fixed. You think, you know, I spent 2 years in federal courts, and you think you go to the highest court in the land, you think you're done. And I'm like, well, I'm not going to quit. And so I didn't get it from the judiciary. I'm going to go to the legislative branch. So I went and learned all this stuff that I'm showing you guys tonight, and I took it to the legislative branch, and I still couldn't get redress that I wanted. So then I ran for office. And these guys, you know, thought I lost Senate race. Well, I ran for governor, and I lose that. I'm going to turn around and run for the Tennessee House of Representatives. And now I'm petitioning my county commission. I am never going to be done. I'm going to fight for this the rest of my life if I have to, and teach my son so he can carry on the fight after me if he has to. I realistically think, depending on what happens with the Court of Appeals in this case, this might get fixed in the next 6 months to a year. If not, I still think with the growth of people that are following my work, I still think I'll get it done in 5 years. And you know, how we got to where we are today, that started in about 1950s. You know, so we're looking at 70 years of incremental corruption on top of incremental corruption, getting worse and worse and worse to where we are. And you know, if it takes me 5 years to fix what was done in 70 years, I'm okay. You know, if it takes me 10 years to fix what took 70 years, I'm okay with that too. You know, we have to, this is our birthright. You know, it's our duty to defend the Constitution. You know, as a Marine, I swore an oath.
well, John, I think we need to have you back because there's so much to talk about. Would you come back?
I'd be happy to. You know, we need to talk about this unconstitutional Board of Judicial Conduct. You guys need to understand what they mean by prohibited pretenses in Article 11, Section 16 of the Tennessee Constitution. You need to learn why did they prohibit hereditary emoluments and privileges and honors? Why did they put that in the Constitution? And I'm happy to share this knowledge with anybody out there. If you don't understand what it means in the Constitution, that's an inherent problem. And I can guarantee if I polled this group of aware citizens here tonight and said, do you know what it means? There shall be no hereditary emoluments, privileges, or honors. Can anybody explain that to me? I can guarantee not a person in this group. I didn't know what it was either until several weeks ago when I started researching it for my book.
Well, John, I want to thank you so much for coming. I know you're going to come back. There's a lot of stuff to talk about.